Well, it's the big story of the day. The Constitutional Court will later this morning hear arguments from the IEC and the MK party on the validity of former President Jacob Zuma's election candidacy. The Electoral Court overturned the IEC's decision to disqualify Zuma based on his previous charges. So what will happen today? Well, my colleague Aldrin is outside the Constitutional Court with the legal expert Macbeth Ncongwane. Let's take you there now.
Yes, so we are outside the Constitutional Court where we do expect that application to be argued on. The IEC, of course, has brought that application following the decision by the Electoral Court. And remember also the other difficulty, Naledi, in this application was that the order came first and the reasoning, so the judgment itself came later on, and it has left a lot of people confused. Even the application that was brought before the Constitutional Court was brought even before the judgments were handed down, meaning the reasons behind how the judges of the Electoral Court came to the decision that the former president is eligible to stand for the upcoming elections. But as you said, we're in conversation now with Macbeth Ncongwane, who is an attorney and also a legal expert, of course, to deal with some of these issues. Good morning. Thank you so much for making time for us. I want to start off here. First of all, the application for recusal of 6 of the justices, including the Chief Justice Zondo. We expect him not actually to sit in on this matter, but there are the other 5 justices, and those 5 justices were amongst those justices in 2021 that actually handed down the judgment that said that the former president must be taken to jail, that he must be incarcerated, found him guilty, and sentenced him to 15 months imprisonment. What do you think about that application?
Well, it's normal for justices to find this kind of applications. They find favor on the well-known case of Sarfu, where Dr. Louis Late took most of these justices to court and brought a recusal application where he suspected that certain anti-apartheid judges that were sitting in the matter where there was a reasonable apprehension of bias. And then he brought that application. So we have developed the test of recusal application, taking it from that. And it's not surprising that the MK party, Jacob Zuma may say these judges were participating where I was found to be guilty of contempt, which Judge Zondi and the quorum, they confirmed that when there's contempt, it's a crime, and therefore what follows will be the sentencing. And therefore, if they've participated on that, the apprehension of bias, is it really there? So this will be a package of those arguments before court to say, now you don't just make it, shout it, you must actually demonstrate it, that reasonably, if they continue to sit these 5 justices, they are likely to compromise or to prejudice me or to be biased, because already they've already taken a position that he was a recalcitrant party in court. He was contemptuous, and therefore he had to go for this incarceration.
And remember the strong language also that Justice Sampear used in the judgment around, for instance, how the former president even refused to send through submissions when he was asked about if the court does say, for instance, that you should be sentenced. What do you think about that? And then also the question around the contempt of court application. He didn't participate in that. And Sampear is arguing that you're now trying to bring in arguments in relation to a matter that has already been decided. But can it be argued that, sure, yes, the justices have dealt with this particular matter in relation to the contempt, but that itself does not mean that they don't have jurisdiction then, and also they don't have jurisdiction to oversee or overhear the arguments in relation to another application that has been brought, which of course is linked to the judgment that they handed down?
Yes, let me break it down to what you are saying. The strong language used by the judges. The judges have a duty to protect the decorum of their institution. And absent those submissions that were requested on various occasions. I remember Judge Mokweng wrote a letter to say, we are in a position to mete out a sentence or judgment against you. Could you please file reasons as to why we should find differently from what the Secretary of the State of Capture wants us to do? And those submissions were not forthcoming. However, I understand that due to the position of the party involved, his stature, and that he was the President of the Republic of South Africa who had an utmost responsibility to protect the integrity of our Constitution as is bounded by it, then the judges felt they have to pronounce on their displeasures. Now, those displeasures, could you weigh them against the appearance of legal practitioners or counsel today to argue the issue of the application of Section 47(1)(e) of the Electoral Act? I doubt that that should be the approach, because this application involves now submissions that have been made.
Yeah.
And I doubt if the judges will be entangled on the past, because that process has completed, has folded, it's finalized. They found him guilty, he was sentenced to 15 months, he went to escort prison, and now the only thing is whether those electoral court judges were correct in finding that there was a violation of his constitutional rights, and emphasis made in terms of Section 39, Sub-Rule 2 of the Constitution, that the interpretation, if anything, that violates the Bill of Rights, it should be interpreted in favor of any person that is...
Let's quickly speak then about the judgments. 3 judgments that came out. The judges even disagree amongst each other, including the professors as well. But they come down to the same conclusion. But I want to go down to the one from Zondi. This is what the argument is. In other words, the conviction and sentence do not take effect until the appeal process has taken place. Alternatively, a convicted and sentenced person has elected to not appeal the conviction and order and sentence. In my view, the sentence that was imposed on Mr. Zuma cannot be said to be a sentence which the section contemplates, and I think this is in reference to Section 47 of the Constitution. The Commission urged, therefore, to uphold the objection of Mr. Zuma's candidacy on the basis that the sentence was imposed on him, disqualified him from being eligible to be a member of the National Assembly. And here's the thing about it. In the rescission application as well that the former president has made to this Constitutional Court, this matter was dealt with. Even in the judgment, the matter was dealt with around appealability.
Yes. Judges in every court may come to different conclusions, but the order is what we must focus on, the order. So I want to make an example, Aldrin. If you say, I want to go to Soweto, you take the N1, you join the Baragwanath, and you are in Soweto. Others, they go via Rudeport, but they still go to one destination. But the reasoning is different. So these judges, and it happens many times in judgments, that yes, the other judge says, my reasoning is in a particular format. That's why it's not advisable to issue a judgment or an order first before you actually couple that with reasons. And you are finding yourself in the quagmire that there's no certainty in terms of the judgment as to what principles should we follow. Because remember, from a judgment, you get a number of things. You get precedents, you get principles, you get the findings of the court in terms of scholarly reasoning of any given judgment that they issue. So now they've issued an order first. However, the judges are coming to different conclusions in terms of reasoning. Now that, in my view, threatened the supremacy of the Apex Court. That's why in the interview of Judge Sienna Jacobs, you could hear the deputy judge, Chief Justice saying, where are your reasons? Because she understands that her position as of possibly the next Chief Justice is likely to be threatened by lower courts challenging decisions that are made in the apex court.
It's an interesting one, and we'll continue the conversation. Thank you so much, Macbeth. We just need to quickly wrap up. So that is Macbeth Ncongwane. He will be with us this morning to give us more analysis around the applications that have been brought and also the arguments and what jurisprudence say about a case of this matter. Back to you, Naledi.
Thanks for that, Aldrin. Aldrin stays outside the Constitutional Court in the run-up to that appearance. Of course, the application heard there by the IEC against the MK party. Keeping a close eye also on the arrivals of support for the MK party outside of the court there. That's on Con Hill.